go ahead and invite people to come in and take their seats. It's my pleasure to welcome you to day 2 of the 2024 Quattrone Center Spring Symposium, From Anguish to Action, Improving Criminal System Accuracy. It's great to see so many familiar friends as well as some new guests here in the audience with us. We also welcome those who are joining us online for the live stream. We began yesterday with some wonderful discussions of a range of issues that highlight the importance of getting things correct in the criminal system. We heard from some talented practitioners. We heard from Sharif Kuzan and his experience, our exoneree fellow. And we're really excited today to be able to have a series of panels that will discuss a range of important issues related to system accuracy. I'm Paul Heaton. It's my privilege to be able to, with John Kodarek, the center, and to moderate the first panel that we have this morning, which is focused on indigent defense funding. So I wanted to take a moment as we get started just to remind, for those of you who are new, how we do audience Q&A. So we are very interested during the panel in getting your questions for our panelists. And so the way we do that is if you look around on the edges of the tables, you should see there's some index cards available. And so as we engage in the discussion, if you have a question that you'd like to pose for the panelists, we invite you to just write it down on the index card. And at various points during the presentation, someone from the Quattrone Center is going to just kind of walk the aisles and collect any cards with questions, bring them up to me, and so we'll be able to work them into the conversation. So we'll do that for all of the panels today. So we hope that folks, as you're hearing and learning, that you can also that we can also answer your questions and engage with you today. So our topic is indigent defense. It's one that's dear to my heart, having published and done some empirical research. We know that our criminal system is predicated on an adversarial model, and the question that we have to think about is if we're in a situation where one side doesn't have adequate resourcing, where there's high caseloads, where there isn't time to thoroughly engage with clients or investigate cases, could that contribute to wrongful convictions? And we certainly see in the stories of exonerees that we featured, in work done by the National Registry, and in many other contexts, examples of situations where wrongful convictions have occurred in part due to just overwhelming caseloads for attorneys. And so we want to talk about and learn about this issue and focus on some solutions. So I feel very fortunate to be able to introduce the real talent here. We have a fantastic panel that has some really good practical insights. We'll see some data today. Let me just take a moment to introduce each of our panelists. All the way at the end, we have Ben Polk, who's a visiting researcher at NYU and who began his career as a human rights attorney, focusing on, among other things, how to enable right to counsel in countries throughout the world. He's currently leading a first-of-its-kind empirical study that he'll talk about that tries to measure how underfunded is indigent defense in the United States. A difficult question. Ben has been doing some really important work on that. I'm a numbers guy, so I kind of like to understand the scope of the problem, and so we'll get some insights from him. So next to Ben, we have Keisha Hudson, who's the Chief Defender in the Defender Association of Philadelphia, a role that she's occupied since 2021. Previously, she was the Deputy Chief Defender in Montgomery County, adjacent to us, and she's had a long and illustrious career at the Federal Defender and also doing indigent defense. Among Keisha's notable accomplishments include successfully negotiating one of the largest raises for our public defenders in the history of Philadelphia, For a very short period, there was actually pay parity between public defenders and prosecutors, right? Significant accomplishment. She's also been a kind of nationally recognized advocate on the issue of indigent defense funding. Next to Keisha, we have Commissioner Rodney Ellis from Harris County, Texas, the third largest county in the United States, which includes Houston. Commissioner Ellis has been serving as the Commissioner of Precinct 1 in Harris County since 2017. Before that, he served in the Texas State Senate, where he authored numerous bills, including bills which tackled many of the issues that we heard about last time. So Sharif Kuzan talked about inadequate exoneree compensation. Commissioner Ellis was able to pass significant legislation in Texas, which expanded access to compensation for exonerations, forensic science, open file discovery, boxes checked. Very impressive, and an environment working together with people who I think on many other issues don't share your ideological commitments, right? But was able to bring folks together in order to make important policy reforms. He'll be talking specifically about some of the important work that he did in significantly expanding funding for indigent defense in Texas, establishing an office to do capital appeals in Texas, as well as now as a commissioner hoping to oversee the establishment of the Harris County Public Defender and a significant expansion. So we've really got a range of experienced practitioners, legislative, academic. I'm very excited. So what we're going to do for the panel is we're going to allow each of our panelists to just provide a few introductory comments talking about some of their perspectives. Again, we invite, as you hear from them, if you have questions, to note those down. And I think we're going to start with you, Ben, to help frame the issue for us.
Lovely. It's wonderful to be here. Professor Heaton, how will I...
Yeah, let me... I'm going to grab your slides, and
okay.
We're going to have you do the clicker.
Lovely. While I wait for those slides, let me just say it's an honor to be here, and it's a particular honor to be introduced by Professor Heaton, whose scholarship I deeply admire, and it's also an honor to be here on the stage with Commissioner Ellis and Director Hudson. And I will say that the deepest aspiration of my research is that it is useful to folks who are doing the kind of work that you have already been so successful at doing, so I hope it can be even further helpful. Okay, so I'm Ben Polk. I'm a research scholar and the director of the Transformative Justice Project at NYU Law School. As Professor Heaton mentioned, before I held that job at NYU, I was the global policy director of an NGO that builds public defender systems in conflict-affected countries like Afghanistan and Myanmar and Palestine and Tunisia. And one of the aspects of that work was working closely with governments to discuss how much money they should put towards indigent defense funding. So when I came to NYU, I really wanted to look at that problem a little bit more systematically and to look at it in my home country of the United States. So it turns out that that's quite an intricate and complicated problem, and I won't get anywhere near covering it today, but I'll give a quick snapshot of how I'm approaching it. I'll give a quick preliminary estimate of what my research is yielding, and then hopefully open the door for Commissioner Ellis and Director Hudson to talk about how they are approaching indigent defense funding on the ground. So it's become essentially a truism that indigent defense is underfunded. And it's really worth pausing to consider how we've let that state of affairs persist, how we've allowed that to become a truism. I want to interrogate what exactly that means that it's underfunded. So the idea of it being underfunded presupposes this gap between what we should be spending and what we are spending. We know, thanks to some recent work by the Sixth Amendment Center, what we are spending on indigent defense, basically $6.5 billion throughout the nation. But what should we be spending? That's a normative question, but one heuristic, one framework by which we could look at this is, what does the Constitution require us to spend? And that's relevant not only in courtrooms, but it's also relevant in legislatures where we venerate the US Constitution. So what should we be spending per the US Constitution? Well, that question breaks down into three other questions. One is, who is entitled to indigent defense services? What exactly is it that they are entitled to, and how much does this cost to provide? Because what they're entitled to is essentially the services of a lawyer per the Sixth Amendment, the assistance of counsel, this essentially creates a basic empirical model of the indigent defense labor market. And it's the objective of my research to develop estimates for what should go into each of those categories. And that will essentially guide the analysis. So the number of eligible cases, the average hours per case, and the average cost per hour. There's two aspects to that analysis. The first is doctrinal and the second is data. The first is figuring out what the actual rules are that govern those questions. And in our constitutional system, the rules that govern the indigent defense labor market are established by appellate courts. So the first step is to review all of the relevant doctrine to really distill what the rules are as they are applicable to these questions. Now, that's somewhat easy when the Supreme Court has answered these questions, especially if they've answered it clearly or recently. And they have done that in the columns under number 1 and the columns under number 2, at least to some degree. In the third column, they really haven't touched on it very much. And so we have to go to state Supreme Courts, including some important decisions in Pennsylvania and other lower federal courts to talk about this. Now, I won't go through the doctrinal analysis, obviously, but what I will say is that one of the things that I hope is beneficial about this way of approaching this question is that a lot of the times in the legal scholarship, these doctrinal lines are treated individually. And my hope is that this way of looking at things helps us see how a lot of these doctrinal issues intersect and speak to one another and influence one another. The trickier challenge, probably the trickiest challenge, is to figure out how to translate what those doctrinal rules are into reasonable, defensible, evidence-based estimates of who is entitled, what are they entitled to, how much does that cost to provide. As you can see in the second line of this slide, already that doctrinal analysis enables us to elaborate that basic equation a little bit. And so for each of these variables, we then now need to figure out what the estimate is for what the Constitution requires. The centerpiece of this, the kind of primary data source, as folks may or may not be aware, but last year several scholars published a National Public Defender workload study that sought for the first time to propose evidence-based averages for the number of hours that public defenders should be spending on particular kinds of cases. Now, this is, in my view, a groundbreaking study. It's been heralded but also criticized, and all of those have good reasons. But what I think its major advantage is it's really the first thing relevant to my research that tries to quantify not what we are doing, but what we should be doing. Of course, it's not perfect because one of the things it does is it creates a challenge in various ways for how to, basically the National Workload Standards identifies averages per case type, and that causes all kinds of problems, and I won't go deeply into those. But that's where we start. The rest of the work is essentially trying to survey all of the existing data that exists to develop reasonable estimates for this. So I like to think of this as well, this exercise, as kind of a applied literature research, applied data review of what data exists in these areas. So I'll leave the sort of deep dive analysis of how I do this to a later date, but without further ado, my sort of preliminary estimate right now is that the U.S. Constitution requires us to be spending about $20 billion per year on indigent defense, as compared with what we are currently spending, which is about $6.5 billion. So it's another way of saying that we are spending a third of what we should be spending, and as I'm sure, or at least I imagine Director Hudson can tell us, that creates a tremendous amount of challenges in the day-to-day practice of public defense that really are sort of unjustifiable under our Constitution. I do want to say one thing about this, which is to say, some people think that, and Commissioner Ellis and Director Hudson have fought so hard to increase funding, and I've been a part of those fights in other contexts, and those can be bitter fights. And so you might have the idea that increasing funding by 3 times is a pie-in-the-sky ideal. And I want to point out that one way of closing this constitutional gap is to increase the funding, but another way is to take out some of the criminal cases from the legal system, to decriminalize those cases and effectively to reduce demand for these services. So to the point of accuracy that is the theme of this conference, one of my hopes is to develop essentially a price tag for what it costs to constitutionally criminally prosecute someone, which I hope can be useful. Now, for my last slide, I want to say that I think that this preliminary estimate, I'm really proud of it. I'm still working to finalize it. I think it's really meaningful, and I think it's the first of its kind, so I hope it generates lots of discussion and back and forth, and we can refine it. But I think less important than that overall number is the lessons learned from how we got there. And one of the things that I'm most proud of is I think that my research yields essentially an equation or an algorithm that local policymakers, or if local policymakers don't do what they need to do, litigators can use to ensure that indigent defense funding is appropriated pursuant to the minimal constitutional levels. So here is my kind of graphical depiction of what this equation kind of looks like. But the point is that it's really, in my view, calculable, and I hope that this kind of research is helpful to folks who are doing this work on the ground. So without further ado, let me pass the microphone on to my esteemed colleagues.
Thanks, Ben. And I'll just note that, we at the Quattrone Center have been working on an empirical study looking specifically at Pennsylvania and trying to map the kind of personnel gaps across different counties. That's soon to be released. I think our results consistent with your findings, Ben, a lot of substantial underfunding, but not universal. There are some counties of different sizes in different regions of the state which do seem to have adequate resources for personnel, and so, I think there's going to be a larger discussion. Thanks for that. So when I hear 20 billion, that seems like a big number relative to 6 billion, and so I think one of the questions we have to ask is, as a political matter, how do we get to a place where there's more funding? And so I want to turn the mic over to you now, Rodney, because you, of course, have successfully fought a number of these types of battles in Texas. And we'd love to hear a little bit more about some of the history there and insights that you can share about, how do we get from 6 closer to 20?
Paul, thank you, and thank you for inviting me. I do have to pay homage to Frank Quattrone and to Denise Bondero because they've done such a great job with having this, and it's so good to be here with Keisha, who helped me out on some advocacy work some years ago, and to be here with Ben as well. I think that it's important to know that as important as research is, and it is, a big challenge is turning these great research papers into policy. I asked a young person that's worked with me over the years, was the first head of the Texas Indigent Defense Advisory Council before it became a commission, if he would look at the talking points my staff put together and the slides and see if he could rewrite them a little bit. And of course, he gave me a lot of stuff, more than I could read online on the plane, but it's all very helpful. But it's the art of turning the great research that you two, in particular, do into policy. And sometimes I think you have to remember the art of storytelling. Now, there's a state legislator from here that I invited. I mentioned on our call today to invite him. And his name is Senator Vincent Hughes. He is truly a practitioner of the art. I'm from Texas, if you hadn't noticed with this southern drawl. But Beschloss did a great book on LBJ. It's called Master of the Senate. And Senator Hughes is very much a master of the Senate here in Pennsylvania. And when he was in the State House, he was putting in legislation calling for a statewide indigent defense system, even when it never got a hearing. And then when the stars aligned and they had an opportunity with a new governor who had been Attorney General, they could make the case. And when I was a state legislator, usually I looked to California, New York, and Pennsylvania. to come up with policy ideas. There weren't many places in the South that I could look. And most state legislators don't have much staff. Texas is probably an exception. They do a decent job now. And even when I was there, I've also found that oftentimes in this space, Keisha, in the indigent defense of criminal justice reform space, the people in state legislative bodies who would know the most oftentimes have been the least willing to step out on a limb on these issues. My guess is in part because they'll have to go into courtrooms and make a living, and they don't want to maybe offend some of the judges, who by and large, once they put on the black robe, get that thing called judge-itis. And they tend to focus just on their courtroom. And they can convince themselves, no matter how far to the left or the right they are, that what they do is justice. And even if they see injustices in another courtroom, somehow they convince themselves they have nothing to do with that. They just focus on their courtroom, and we'd never change anything that way. I'm not a criminal lawyer. I used my law degree to become a small-time investment banker, and I lobbied with my practice. I'm still with a law firm, but they got me on that hourly rate, so they had to pay me a lot of money. And at my age, I have a very limited patience, amount of patience. It had to be a client I really want to help. I don't touch it. But so you don't have to be an expert in the space. I put in a bill for indigent defense when I went to the Texas State Senate in 1990. That was a long time ago. It was before Ann Richards was governor. We have biannual sessions. I think they do that here, right? We have biannual sessions. So I get there in 90, and I told my staff, put together a legislative package. You didn't have the internet in 1990. Nobody had thought of it. So they would look at Governing Magazine, which you didn't get online, and they'd call New York, California, Pennsylvania, and get ideas. None of those states really gave me this idea. I had a staffer whose sister was a public defender, Keisha, in Baltimore. And she said, you know, we're from Houston. They need to have more public defender offices. So you ought to put in a bill. Young guy on my staff who became a legislator later, Mark Strama, his sister was the reason I put in the bill. It never got a hearing, never went anywhere. And then when the timing was ripe and I saw a window to pass a bill, I passed one in 1999. In 1999, Governor George Bush was running for president. And I compromised on the bill. Two ways you pass a bill. One is when everybody knows what you're doing. The other one is when nobody knows what you're doing. And after I'd been there a while, they would, anything with my name on it, they'd read it and read it very closely. And usually I'd do very long bills. So I compromised. It was a better bill than the one that passed, which is in effect now, passed in 2001. But the bill in 1999 did not provide any state funding, but it pretty much mandated all 254 counties to have a vote of the Commissioner's Court. Most of these are 5-person governing boards to decide whether or not that system was fair. One reason I did that was because a public defender with rural legal aid told me he wanted to sue. He wanted to go to court to make the case for adequate funding. But it was so difficult to sue judges. So he figured you could sue commissioners' courts. A guy named Jerry Wesovich, who's in New Mexico now. So I was fighting to do that. And every time one of my colleagues to the left or the right would say, I think you ought to change this. Good idea. Let me change it. But I'd add 3 or 4 more paragraphs. So I came up with a pretty good bill that maybe everybody hadn't read. Then Governor Bush vetoed it. And then it's good to have a network. When he told me at a signing ceremony he was going to veto that bill, he said, Rodney, most of the letters I've gotten have been from your friends. They're black lawyers in Houston. So I'm going to veto that bill. So he vetoed it. Then I got someone to do an open records request to see who these people were. I could have done it, but that would have been rude. And the man was running for president. After all, you know, if he lost, he'd be back as governor to veto my next bill. So I got somebody to ask so I could see who they were and find out why. It's because in many parts of this country, we still have this old system, which is an inherent conflict of interest. It's sleazy, where the judge picks the lawyer for someone who's indigent and accused of a crime. It's as sleazy as you can think of. Judges don't pick. Prosecutors, why would a judge pick? And they convince themselves that somehow they know better for these poor people who come before them. So that's what I was up against. So then I worked my network of legislators around the country. So when Governor Bush showed up in, of all places, Iowa, they had a black state senator and 2 African Americans in the state house. And when he showed up campaigning, people were asking, why did he veto that bill? And then I go to make the story. I found a case, famous one out of Texas, sleeping lawyer on a death penalty case. And the Texas Court of Criminal Appeals, which is the Supreme Court for criminal matters, ruled essentially, it was a nice long, one of those long opinions that I hated to read when I was in law school, and you get something called Cliff Notes. They still have those. But you just make it succinct. It basically said he was awake during the important parts of the trial on the death penalty. And when I got that line out of the Cliff Notes, hallelujah. And I would have people around the country. We whipped up such a frenzy working my network of progressive legislators, Hispanic legislators, and black legislators. At one of the presidential debates, they asked, why did you veto that bill? And he scrambled, oh, Rodney is my friend, Senator Ellis. And I'm sure they're wondering, who is Rodney? And then we had a guy who was convicted with a lack of DNA testing. And so I used that as an opportunity to help make the case. So look, the short of it is, here's what we've done in Texas. I'm glad Pennsylvania has followed our lead. This was one of the last 2 states, I can't remember the other one that does not have, North Dakota is the other one, not in the South. I thought somebody would have said North Carolina or South Carolina, but North Dakota. So Texas has tripled spending since the passage of the act. In 2001, counties expended approximately $92 million. Most of it is on the counties, 254, on indigent defense services without state assistance. In 2022, county and state spending together totaled $344 million. It's not nearly enough. What Pennsylvania has done really is a big deal. Texas is 31 million people. Pennsylvania's 10 million people. So, I mean, it's a big start, but we put in standards along the way. It helps. So in a state like mine, what has helped, even getting bipartisan support on the things that I've been able to do, is because Texas, in many ways on these issues, is such a dark place. And it's easier to find some light when you're in a dark place and you try to make a difference. So we have made tremendous progress, but considerably more to do. And I'll save the rest of my comments with you.
All right, great. And you know, I will just point out, Rodney, that 92 million to 343 million, in percentage terms, that's about the same as 6.5 billion to 20 billion, right? So, yeah, so I did, you know, I mean, I don't think you want to minimize, right? So we just said, hey, huge gap. Would it ever be possible to, you know, close that? And I think we're hearing about an example where there's been that level of an increase in funding over time. Keisha, I want to go over to you. You obviously have to live with the day-to-day realities as the administrator of one of the largest public defense organizations in the country. You know, I think relative to some other places, better funded in certain ways, but still you have to deal with the reality. I'd love to hear from the practitioner's perspective how you see some of these conversations about funding playing out. And, you know, you also, again, have taken some of your precious time and energy, and there's lots of demands, and, you know, really become a very vocal public advocate for this cause. And I'd just love to understand a little bit more why it's so dear to you.
in September I'll mark 22 years as a public defender, and I don't imagine that I'll do anything else with my career but do this work. I think it's incredibly important work, and one of my mentors, Jonathan Rapping, who's the founder of Gideon's Promise, a former defender at the Public Defender Service in DC, says that mass incarceration is the civil rights movement of our time. But no one is marching in the streets, and no one is doing a sit-in or taking over a building and or protesting to demand funding and to demand that we do more to reduce our incarceration footprint. But public defenders are, and we do it quietly. And I think one of the things that I've realized over the last 2 decades is the need to be more proactive and more out front around the resources that we need to do this critical work that we do, this constitutionally required work that we do. Funding is important to me because we talk about why people come into public defense, right? Some of us are warriors, some of us are just anti-establishment, some of us are social workers. But at the end of the day, right, we know that we're the only ones standing in that courtroom facing the immense resources of the state. And last year, the Defender Association represented 38,000 people in Philadelphia, 34,000 adults and 4,000 children. And we did that with 250 lawyers, and we had around about 250,000 court appearances, right? We track the data of every time we go to court for a client, from arraignment all the way through to that sentencing and or argument before the appellate courts. We in Philadelphia are better funded than our county counterparts, right? I was the deputy defender in Montgomery County. And just to frame, what our funding looked like there, Montgomery County, at the time, we were funded at $5 million per year. The Department of Probation was funded at $10 million per year, and the prosecution's office was funded at $20 million per year. And so grossly underfunded. And the Philadelphia Defenders Association's budget is $62 million a year, and I say that, and everyone thinks that's a really large number. But I will tell you, we are also grossly underfunded when you look at the volume, right? 38,000 human beings, 4,000 children that we brought into the system last year alone. So I'm very passionate about funding because we do not have enough resources. I did death penalty work for 10 years where we also represented clients in Texas. The Capitol Habeas Unit has had clients executed around the country. And when we talk about depriving someone of life and depriving someone of liberty, right, we should all want the person standing next to that client to have all the resources that they need to hold the state to its burden to prove that the person that they have arrested and or charged and are prosecuting, and they've done everything that they are constitutionally required to do, has the most excellent and most well-funded advocates standing next to them. And we're nowhere near that point. So while I'm very happy that Pennsylvania is funding public defense for the first time, it is $7.5 million, and while I'm grateful to Governor Shapiro, grateful to Senator Hughes, who's been fighting this for a long time, Speaker Joanna McClinton, Representative Napoleon Nelson have all been champions for indigent defense funding. But that's $7.5 million for 67 counties. And if you divided $7.5 million by 67 counties, each county gets about $113,000. The Defender Association, compared to where our counterparts are, should not see a penny of that because there are public defender offices where there is one defender in the western part of the state who has no staff, and she has 900 cases. There are public defender agencies across the Commonwealth with no investigators, no social workers, no paralegals. In Montgomery County, our copy machine would break. We had one on a weekly basis, and we'd walk over to the clerk of courts to make copies. So, we have a really long way to go. I'm glad we're off of the list of states that do not fund public defense, but $7.5 million is really just the beginning of what needs to be a much more robust funding for public defenders across the state.
Yeah, thanks. And you know, keep your eyes peeled for our study, because I think it's going to confirm some of the things that Keisha, and give a little bit more numbers to that. But I think very consistent. We've had some very interesting questions from the audience about a range of topics. Let me start with one. So you Keisha, mentioned investigators, support staff, social workers. There's obviously a lot more that goes into providing good defense beyond just criminal attorneys, as important as they are. So we had one question from the audience for you, Ben. How should we think about those other folks in terms of these calculations, right? And yeah, I'd love to hear thoughts and perspectives. I know that one of the things with the Houston, or the Harris County Public Defender, that as I've watched it develop and grow, it kind of started with that holistic mindset and an idea that we need resources to have the necessary support staff and other folks. So I'd love to just hear more about this issue of how do we think about all of the other non-lawyer inputs.
Shall I go first? Yeah, it's a great question, and it's a hard question. So the National Public Defender Workload Study asked these 33 experts how much time they should spend, how much time the attorneys should spend on these cases, but they also included a line that essentially said, assume your current levels of support staff, but they don't actually quantify how many support staff are in there. And by support staff, I mean legal secretaries, paralegals, investigators, social workers, et cetera. So those numbers into my calculations are essentially baked in, but I still need, and I do some work to sort of quantify how much they should be, because I think the fact is that one of the things you see in a lot of jurisdictions is that they will have some support staff, but not nearly enough. And one way to get at that question is there are certain jurisdictions that essentially provide two different sets of caseload standards. They say if you have no support staff, it should cost this, many hours per case. But if you do have sufficient staff, it should be this number of cases. And the National Association of Public Defenders has put out some really useful ratios of what those ratios should be between those support staff. I will say that there's one sort of set of what you might call support staff that I think the Constitution, nobody can make, at least I don't think anybody can make an argument that the Constitution requires holistic defense being treating not just the immediate criminal case, but all of the other ancillary issues that contribute to why that person is involved with the public defender system. However, even if there's no sort of constitutional requirement for holistic defense, people, including Professor Heaton, have done incredible research to show empirically what I think a lot of us know to be true generally, which is that holistic defense is a much, much better system because people don't come into contact with the criminal justice system out of nowhere. Oftentimes there are a myriad of contributing factors that contribute to things like this. So I'll stop there.
So Keisha, you have to face this on a very practical level, right? Because you have to think about balancing the different, kind of attorneys and hiring social workers. I'd love to hear your thoughts about that issue of, particularly in a world where there's limited resources, how do you, kind of make sure that you've got the right mix of folks, and how should we in the public be thinking about that issue in terms of figuring out, are we providing enough to our public defenders?
So for those 38,000 people that we represented last year, we have 29 social workers at the Defender Association of Philadelphia. We cannot do much more than refer, right? And so our social workers carry incredibly large caseloads, and we connect. We do a really great job of connecting our clients to services, but every study out there shows that the really best model is an interdisciplinary one, where every client that comes into the justice system gets assigned a social worker that's going to work with that client throughout the entire, process. Connect that client to services, help that client navigate all of the immense bureaucracies that our clients really are not equipped to navigate. With the resources that we have, we cannot do that. We cannot do a case management interdisciplinary approach. We refer clients to services, we help connect them to those services, but then we have to move on to the next client. We don't follow through, and we have no time to ensure, did the client make their way to that appointment? Was the client able to get the public benefits and or navigate the public housing and or get the appropriate mental health interventions that client needs? Again, we connect them. We check in on them perhaps maybe once or twice pre-trial, certainly not post-trial, where again we have no capacity to be able to ensure that client is connected to those services. I implore everyone to check out the Inquirer's study around the 57, it's called the 57 blocks. When people talk about pre-COVID and post-COVID and what's going on in Philadelphia and the rise in crime and the rise in gun violence and everybody, we're all shaking our heads, why is this happening in Philadelphia? And when you look at that study, starting in the 1930s and well before then, Philadelphia Inquirer identified 57 blocks that are, where you have the most violence, right? 10 or more shootings per year. And they identified 57 blocks. It's now up to about 80 blocks. And when you look at redlining in the 1930s and you look at that Philadelphia map of redlining, and I think we all know what redlining is, you overlay that map of redlined areas and neighborhoods to the 57 blocks, and 53 of those 57 blocks were redlined in the 30s. So this is all by design, and I get really angry when people are kind of scratching their heads and wondering why do we have this rise in crime? And let's be clear, the majority of people we see at the Defender Association are black and brown. 99% of my youth clients right now are black boys. So, let's not pretend that we don't know why we are here and what has led to this. It is by design. It is by deep disinvestment in neighborhoods in Philadelphia. And if we're really to address those root causes, we need people in the system like social workers, like mitigation specialists who can tell that story of why is this client before us, what got them here, and then when you go back 3 generations as we do in death penalty work, and you realize that this has been a multi-generational design process, and this is why this 13-year-old child who can't barely see over the bar of the court because they're so short is before you today. And while I would prefer to not have that client be in the system, let's do everything we can and fund the people like social workers who can help, we hope, get them out of the system with the least collateral consequences and hopefully break that cycle of incarceration.
Great. Any thoughts that you want to share, Rodney?
Obviously, it's a problem in Texas as it is around the country. I assume in New York, they probably do more of a social net than anywhere else, and even there, it's not enough. We're at one of those inflection points where there's less sympathy now than there was, say, 4 years ago after the George Floyd tragedy, who, by the way, was wrongfully convicted. It was not the first run-in he had with the law, but he did have a run-in with what turned out to be a dirty cop planting drugs like $10 worth, and our public defender did take that case on. I encouraged him strongly, although it didn't matter, he was no longer with us, but to make the point. And he had a court-appointed lawyer in that case. There was no public defender in Harris County at the time. But, for a short period after the Floyd controversy, I think that was an opening. It was an inflection point to do a lot of positive things. It lasted longer than I've seen that happen in the past. But I always assumed it would end, and I wish that we'd done more. I mean, after he was at one of his funerals, the main one was buried in Houston, in the precinct area that I represent. So after we went, I put several items on the agenda. I told my staff, whatever you can think of. Now let's pass those resolutions that I hate. You're just killing trees, passing more resolutions. But let's resolve to get our public defender's office up to 50% of the cases. And here I am. This will be the 4th anniversary of his death, and I'm still at about 20%. Some good things came. We used your study to get misdemeanor bail reform, which shot around the country, by the way. But, look, blood and gut sales with the Philadelphia News, all of the local national affiliates. It's easy if you're lazy as a reporter. That's an easy thing. And it captures our attention. But you know, we still have in every county in this country, the largest mental health facility is the county jail, which makes the case. You know, why are we putting people who clearly have issues deeper than just the crime they may or may have not committed? But that jail is the largest mental health facility in every county in America, including, we don't have counties in New York, but the jails are where you put most people who have mental health challenges.
Absolutely right.
So I think those were really interesting comments. I want to kind of put my abolitionist hat on for a second here. So, I guess one argument that I might make as an abolitionist is, sure, we're talking about expanding services, but in the context of a criminal legal system, which is deeply unjust. And, what we don't want, we actually don't want more public defender funding. We need to shrink everything. We agree that there need to be services, but why can't we provide those services outside of the context of a public defender office, outside of a context of the jail? Yeah, I'd be interested in folks' thoughts about that.
I'd say provide it wherever you can. I think the argument of parity. So if you're going to cut everything, usually when you have a shortfall and you're cutting, I suggest a scaffold approach instead of across-the-board approach. And virtually everywhere in the country, I don't know about New York, I just have not looked at the empirical data on it, but most places in the country, you have far more, the sheriffs, the constables, police do the investigative work for the DA. You clearly have an advantage because you file charges in the name of the state. When you are the public defender, you are trying to defend that person on your own. But so when you make the argument for parity, it's rarely achieved. Kudos to you for getting it 3 months. But philosophically, when I try to make a political argument, I guess they teach in law school, argue the other side, and I'll hear that voice in the back of my head arguing the other side. Sometimes when I was in the legislature, I had to say, shut up, I'm trying to make my point, But if I were on the other side, the parity argument helps. And clearly, I would prefer that the mental health or those social services are provided in an independent way. So if the person whose duty is to represent you, they're better at it. But look, wherever I could get it, looking on this funding for indigent defense, by the way, I'm not proud of the way I funded the bill, the state money in Texas. I always argued against these regressive fees that have a disproportionate impact on poor people. But the way for me to fund it was I was finance chair to just fate. It was luck. I had the pen in my hand just for that one session. I knew they'd get that pen out of my hand at the next one. So I did all I could. So that was a fun I swept. It was a sleazy court fee put on poor people in all of these cases that would come up. But we were not using it. It was just sitting there as a trick of finance to balance the budget. So I took it. When I say I swept it, I stole it. I took it and put it in indigent defense. Then my Republican colleague said, hey, Senator Ellis, I thought you were against regressive fees. So my response was, I am, other than for a progressive cause. But by using it that way, eventually the state put general revenue in. So, well, look, to answer your question, however you can get the social services, take them.
Yeah, I guess I would say, I agree with Director Hudson that mass incarceration is the central issue of our time, and I think the central civil rights issue of our time. And, a point that you make, Professor Heaton, in one of your papers is that to date, at least, most of the mass incarceration energy has focused around issues like policing and sentencing, and it really hasn't focused much on the role and the potential role of public defenders in reducing mass incarceration. And as Director Hudson points out, that's a clear oversight because public defenders are on the front line every day of fighting against mass incarceration. And what some really exciting recent research seems to be showing is that increasing public defender funding, decreasing their workloads, it doesn't have the impact of changing the rate at which people are convicted of crimes, whether determined to be guilty versus innocent. But it does have a significant impact into how much time they are given, the length of their sentence. So if you do want to decrease the footprint of our carceral system, investing in public defenders, I think, is a critical way of doing that. But another answer to the question is the point that I made in my in my statement, which is the need for public defenders comes only from government action. It's not a demand that's independent. It only is triggered if the government is prosecuting someone. So another way to reduce mass incarceration without providing more funding is to take a lot of the types of criminal cases that we currently handle inexpertly in our criminal justice system and put them in other modalities that aren't that don't have the same cost and the same long-term harms that come from that kind of treatment of those problems.
So in the next week, I think in the next week, because the 100 days is about here of the mayor's first 100 days, there's going to be a plan released to address what's going on in Kensington and address the opioid epidemic. And the fact that the police are going to be central to addressing that issue and not have it be a public health issue has raised all of my alarms. There have been about 12 meetings so far of different stakeholders to talk about, what should the approach be. I've been invited to 2 of those 12 meetings, but we're talking about bringing people into the justice system, and I'm constantly trying to insist and invite myself and implore stakeholders to make sure that the public defender always has a seat at the table when you're talking about any increased enforcement and bringing more people into the justice system. The Kensington issue should be solely a public health issue. It started out as a public health issue. I will tell you, most of our clients who are addicted to opioids started out with that knee surgery, and they're coming from the counties, right? We're imagining that people are just in Kensington and they're addicted. They're from Montgomery County, and they're from Bucks County, and they're from New Jersey. And it should be a public health approach, but the police is going to be central to that strategy, and very few people are demanding and are insisting, should the public defender be here, and we should invite them into this space to talk about really what the best approach is. So I don't think that any police agency should occupy 30 to 50% of a city's budget, which is what we see around the country. I think in Philadelphia it's around 30%, right? In the last 8 years, the police budget has gone up $220 million alone. I think it's around $880 million right now. Police officers don't prevent crime. They don't create public safety. They come when a 911 call is made, or they very less often may see a crime occurring, and then they respond to it. So there's so many things that I think we need to be investing in up front, and I've changed my language in some ways. I used to talk about red flags. It's a term that you hear a lot in capital death penalty work, and I stopped using the term red flags, right? I now frame it as missed interventions, and public defenders are the only people in the system who can tell you a mile away, right, how did that client come into the system? And those missed interventions have to do with the failure of so many things in society, starting with our public health system, our education system, those disinvestments that I talked about that have brought our clients in the system, and why aren't we pushing resources and funding and prioritizing funding for those interventions? Why is it the first time my client gets the proper medication for schizophrenia when he has committed a crime, when all of the institutions before then saw that this was someone in deep need of help?
I would add to that, when somebody on my philosophical side of the aisle came up with the idea of, wrong language, defund the police. In Texas, they passed this legislation called no defunding the police. And so many right-wing think tank ideas come out of Texas. It'll sweep around the country. So the law enforcement budget, boots on the ground, is 45% of my county's budget. about the same for the budget for the city of Houston. And if you run those social services through that department, and then in states where the far right controls the state house, state senate, and the governor's mansion, they'll pass that, you'll never get it out. So it's a good reason to be concerned about it. I do remember when I started my career, when Ann Richards became governor, who suffered with addiction, alcohol. So did the president of the Senate, the lieutenant governor at the time. So we invested a record amount in the drug rehab programs in the prisons. So then we got to the point where if you had an addiction, you wanted to get off, the best place to go was to jail. Now, if I thought about it as a baby senator in 1991, maybe I would have said, is there some other way to do this? And we were spending so much money. It was a bond issue. You build the infrastructure. Politically, it was a way to pass it because you had law enforcement behind it, so they got it. And then when Governor Bush came in, they ended all that. We were spending so much so quick, we had problems. The other point I want to make is when you're trying to make a case for indigent defense, I always used a wrongful conviction in a positive way. Sometimes I feel guilty. Attorney Durso, should I get it right, is here. He's an exoneree, went on to go to law school. But I take their cases and I look for what policy issues can come out of it. That's how I passed what at the time was the strongest discovery statute in the country, and of all places, Texas. New York has surpassed it. Theirs is a bit stronger, but they can be a little wishy-washy too. They may go back and gut it in succession like they did bail reform. But I would say anytime you can, you take a wrongful conviction, it happens. We are talking about a government a system, but most of those are from court-appointed cases. Rarely is in a public defender's office, and that helps make the case for more funding for public defenders.
Yeah, thanks. I mean, I feel like these were all very helpful examples of ways that, public defenders can reduce, the scope of the system. I mean, as you were talking, it just reminds me, I got in, my first law review article was one about the Defender Association in murder cases, and we found there that, the decision to have the Defender Association take only 1 out of every 5 murder cases as opposed to all the murder cases in Pennsylvania implicated about, by our estimates, very conservative estimates, about $200 million in incarceration costs for the state of Pennsylvania, right? So that was a decision at the time. I don't think someone thought they were writing a $200 million check, and with all the human costs and costs of wrongful convictions, when they made that decision, but there we were. I want to shift gears because we've gotten a couple of questions about the role of prosecutors in all of this. And, Rodney, you raised this issue of parity, right? And shouldn't we be thinking about relative budgets? One of our audience members is interested in thinking about, does having progressive prosecutor, does that help? Does that matter? Are prosecutors allies here? Are they potentially obstacles? So I'd love to hear perspectives of any or all of you on, thinking about, what prosecutors can do, and maybe, if we need to say, like, in an ideal world, what would we want our prosecutors to do? And, if we want to speak about the realities as well.
I think the position of prosecutor is the most powerful elected position in the country, with virtually no checks and balances. And in fact, some ways it's almost scary. I would say, to the extent you have a progressive prosecutor, I don't want to use that term, they demonize it, a rational prosecutor, you ought to try to do as much as you can while they're there. So under that Fair Defense Act I passed, the first one didn't require the judges to have to agree. The one that's in effect now says that 2/3 of the judges have to agree on it. And of course they vote in a secret ballot. They're in that back room with the black robes off. We don't know who's voting how, but it's all in a black box. It's a mystery. And when people would ask, well, why would you accept that? Because I wanted to bail. I mean, you're getting standards. You're getting some funding for the first time in the history of Texas in 2000, passed in 01, went in effect, 02, it went in effect. That's why I did it. But, my county hadn't done it. I was in the state senate. I had to push to do it, but it was the prosecutor killing it. So when Harris County, Houston, created the public defender's office, I could get 2/3 of the vote because the prosecutor at the time was having challenges because of some marital infidelities that were all over the newspapers. And I was chairing the board of the Innocence Project, so I could get Barry Scheck, get Peter Newfield, so it wasn't me. I had an army of lawyers and people behind me to get that 2/3 vote. And because the prosecutor was dealing with these challenges, that office was vulnerable and could not fight it. So with the wave of a hand or some public support, in a big way, a prosecutor has. But look, whether you're on the left or the right, I mean, you get the wrong person in that office, and it's like J. Edgar Hoover all over again. And so it is a very powerful position in our system of government that should not remain so unchecked. Okay, madam.
This is live streamed. Hi, DAO Krasner. In full disclosure, when I worked at the Justice Collaborative and the appeal, and very much behind the scenes, worked on some of Commissioner Ellis's successful campaigns and legislation. We also did a lot of work around getting progressive prosecutors elected. I think one of the important things that I think progressive prosecutors need to keep in mind is that they're going to be blamed for all the things. And we see that around the country. We see that in almost every jurisdiction that you've had a progressive prosecutor. We see it here in Philadelphia. Even though the police are the ones who make the arrest and the prosecution is, are the ones who make the charges, right? Any rise in crime, whether the data supports it or not, is right now in Philadelphia being laid squarely at the feet of DAO Krasner. And I think on some really important issues, right, I think we're up to 35, maybe more folks who have been exonerated under DAO Krasner. We do not have any capitally prosecuted cases, which for our unit, the Defender Association, one of the, I think, the best homicide unit in the country, right, is a relief for us. But I do have some concerns about what happens, when he decides he's either not going to run again and or he steps down. And the pendulum has already started to shift. And so for every progressive prosecutor, what I would like to see is some succession planning, put in a lot of effort to put the right people in place that are going to carry those policies forward, and ensure that, when that prosecutor decides to move on, or decides not to run again, or perhaps gets defeated in an election, that those policies that are embedded within the institution get carried forward to the next person who's going to hold that position. And I'm not seeing around the country a lot of success in that happening. I see that once they leave office, right, the pendulum shift kind of goes back to regressive and traditional prosecution policies. And I have a similar concern that that's what we're going to see here in Philadelphia, and that we're already seeing some of that happening. Because the narrative of what's happening in the streets of Philadelphia is being laid squarely at DAO Krasner's feet at the moment. And he's in some ways responding and has to respond to that pressure.
I'll just interject. That's a really interesting point you raise, I think, because it also has some resourcing implications as well, right? We think about an office in some sort of static ways, I think sometimes as researchers, but obviously one of the things you have to think about is how do I maintain the necessary capabilities for the capital cases, for the retail theft, other types of cases that might not be here today, but maybe tomorrow they will be here, and we need attorneys that are available, knowledgeable, trained, ready in the event that happens. So that's kind of an interesting, I think there's an interesting resourcing angle as well there.
No, we haven't shifted, and in fact, my I'm always succession planning as a leader of an organization that, we're today having a gala to celebrate the 90th anniversary of the Defender Association. We've been here for 90 years. And I don't want us to change our funding strategy, training. All our homicide attorneys could go into court next week and do a capital case because they're 801 certified. They go to conferences. They're maintaining their skills. We still put 2 attorneys on every homicide, even though we don't have the death penalty, because there may be a time, and I think there will come a time when we may have to jump right back in and handle those prostitution cases and the retail thefts, the simple possessions, the capital case. Again, that's not been the reality, for the last 8 years or so. Our youth cases are down to a third of what they were pre-Krasner, right? And so for our youth practice units, we can't look at it as, we don't need as many resources now because we have a third of the cases coming through the juvenile justice system, because there may come a time when diversion is no longer a part of our practice, and right now under Krasner it has been a significant part of our practice.
Yeah, the only thing I would add is I think that's right. I think prosecutors play an absolutely essential role, especially because their power is so unchecked. And I think it's also true that they face very real political pressures. Prosecutors stand up in front of the courtroom and say, we represent the people, and the mandate of prosecutors is not to maximize convictions or maximize incarceration. It really is to do justice. That is their explicit mandate. I think historically they have been responsive to a very narrow conception of justice and a very narrow, not necessarily narrow, a significant but not universal slice of the people that speak to them. And so I think more and more we're seeing prosecutors try to listen to a broader range, incorporate ideals of justice and mercy into their work, but at the same time, they are facing some real political ramifications for doing that. So it's a hard job, and I think their job is not only to change the way that they're carrying out their work, but also to really educate their constituencies about why they're doing that and what the long-term benefits of those changes are. And it's a hard task, and it's a hard task.
Thanks. So I want to switch gears to another topic that, again, a few folks have raised in questions, and that has to do with this question of who ought to be eligible, right? So, it's easy to just think, hey, the state comes up with some formula, we apply the formula, and then people go to the Defender Association. What role should our public defenders have in advocating around eligibility for services? Is there a tension, right, on, if we make more people eligible, that takes the resource problem and potentially makes it even worse, right? More of a challenge, right? We've got more cases now. So I'd love if you have thoughts about this question of who ought to be eligible, how do we decide that, what role do public defenders play in shaping the set of policies we have in that space?
I can start on that. So eligibility is determined by whether you're indigent and whether you face an actual risk of being actually incarcerated. This is under the Sixth Amendment. A lot of states have gone beyond that when it comes to the actual imprisonment standard. But one of the things that I will say is that lots of scholars have documented that the way that states and courts apply indigent standards are nowhere near the alignment, in alignment with what the Constitution says they should be doing. A lot of times they will be taking these very formulaic approaches to things where they say, do you or do you not have income higher than 200% of the federal poverty level, et cetera, and they are applying these in very straightforward ways when the doctrine really asks for them to make a much more individualistic determination of this. And I think, one of the things about the national workload standards that comes out is it really shows that the cost of hiring a real, a meaningful attorney on the private market is much, much higher than we had thought it was previously in this case. So this is a long way of saying that I do think that many fewer people are getting public defense services than really should be getting that. And I think that there needs to be a lot of advocacy around how courts are making that determination. The last thing I'll say about this is once you're deemed eligible, you still might not get a public defender, and the reason for that is you can waive your right to a public defender. In urban counties, a lot of the research suggests that for serious crimes, people aren't waiving all that often, but the research is also showing that for misdemeanor crimes and also in rural areas, the waiver rates are incredibly high, and there really is a question as to whether or not a lot of these waivers are valid, whether or not people are being pressured, structurally coerced into waiving their right to counsel. And there's all kinds of anecdotal kind of horror stories where judges are saying, like, well, you've got to try to negotiate with the prosecutor, and only if that doesn't work, then I'll appoint you a public defender, which is like, has got the horse before the cart. So I think there is a lot of room to deal with eligibility. And you're right, that would increase the number of people that require this. But again, we've got to uphold the Constitution. And if people have a right to it, that's got to be honored.
I'd like to not give that discretion to the judge. I think if you run the numbers, I mean, you're the statistician, the expert at it, might I add. There's far more of a gap between those of us who have and those who don't now than there was previously, and it's growing even more. A big challenge is, at least in many parts of the country, the South in particular, is to get away from this system where you have these court-appointed lawyers. I want to stress that because 80% of the cases in Harris County, it's still the judge picking the lawyer for the person. So in a good part of the South, up here, you all want to argue that you want adequate funding for public defenders. Hell, we just want the public defender. Even if it's inadequately funded, because it creates that institutional structure to make these cases. Most politicians don't want to go and do that. Another point is I encourage public defenders to get into the fray and run. First opportunity, I had some influence on the county level of appointing a misdemeanor judge because one of our great jurors passed away. And when she passed, I went and recruited a public defender to take that slot. And then another one on my staff, I encouraged her to run. Not as quick as she ran. She'd gotten mad at me. But she beat him. She won. And is doing a great job. Here, Keisha's predecessor is, I didn't know till we were on that call. She's running, and a public defender running for attorney general of this state. I don't know if she'll make it or not, but I'm going to write a check. It won't be a Texas-sized check. It'll be from the heart, though. So I encourage them to get into the fray. Oh, there he is. Senator Vincent Hughes. Give him a round of applause. You were not here. I was singing your praises behind your back. I hope they usually throw knives behind my back.
Any thoughts, Keisha, on the eligibility question? Yeah.
So we represent 70%. We can't represent 100%, obviously, because of resources and funding, but also because of conflicts and cases where there are multiple people being charged for an offense. And there was a great article last week in the Legal Intelligencer. There's going to be one forthcoming in the Inquirer to talk about really the crisis of court-appointed counsel. There's a list, right, that you have to get on the court-appointed list. And there are a couple heroic lawyers, one a former defender, Kate Kachamani, Brianna Shaw, again, another former defender, who are excellent attorneys who take court appointments. But the article points out, right, that the city of Philadelphia sometimes takes, a year or more to pay for court-appointed counsel. There's currently, to this day, I think, no investigators or maybe one investigator that actually will work on court-appointed cases because they're not getting compensated by the city. And so we have a large population of people who don't, we can't represent for a variety of reasons, but they get counsel that are not resourced. And so if you can't have an investigator on your case, if you're not going to be able to have that expert, or if you have to go to the court to get the voucher signed to get the expert, then what is the representation that you have at that point? It's really not effective at all. And a lot of the lawyers who are on that court-appointed list are lawyers that, I have sat in courtrooms and they have walked in and introduced themselves to the client before they're picking the jury on a really serious case. And that's the first time they have met that client in that courtroom. And there are potted plants, and that's really an insult to potted plants. So, because really great lawyers, you have to, to do a quality representation, you need resources, you need experts, you need investigators, you need to prepare for that case, and you cannot do it out of the goodness of your heart. You need funding to be able to compensate people to do the great job that they need to do for that client. And so most of the really excellent lawyers, absent just a few that I've mentioned, do not want to take court-appointed cases because they're not being compensated, which leaves, the aforementioned potted plants in the courtroom representing clients facing serious consequences in Philadelphia.
Go ahead.
I want to stress, I'm not against court-appointed lawyers. I'm against the judges making appointments. So I think it's out of Massachusetts. I think that's where we got the idea from, Senator. So I've created a MAC system, passed a bill so that counties can create a manager-assigned counsel. The public defender can make the appointments. We also do dashboards in Texas because the state's so big in so many counties. But there's a dashboard, and on that dashboard, it shows how many times you met with your lawyer. And sometimes when you put so much out, all this paperwork they put together, because I couldn't sleep on the plane, Vincent, I was reading all this stuff that they create from my making our advisory commission a statewide agency now where the governor appoints a board. They no longer give it advice. They have some power, but they do these dashboards. And on a local level, I do it. So we can see how many judges use the public defender as opposed to appointing a lawyer, whether or not they use a MAC. Transparency is a good sanitizer with most things. Last point I want to make, I thought about Senator Hughes being here. Today is the anniversary of Martin Luther King being assassinated. And so you think of what he did, being black, being a minority, with a relatively small number of people who really followed. More people followed him publicly in the news than would show up for marches, which is why he went to kids to make the point. But it's sort of like we need whatever it takes to tap that consciousness. Most people just don't know. They don't get to see your research, to see how awful things are. And most people don't want to know. So you got to use TikTok or whatever the other one is to really get the message out so people realize just how unfair this system is in these United States of America.
Thanks. This has been a really rich discussion. With our last little bit of time, I think you've given a great, I'd love to invite the panelists to say, where do we go from here? What would you have folks do? You've given, I think, a great set of counsel for us, and I'm excited. In a moment we'll get to hear from Dan and Lester, two people who have spent their lives trying to elevate the stories that can change people's minds and expose some of these things that people want to look away from. I'll give my thought for what to do. Read our study when it comes out, and when you see the numbers for Lebanon County, for example, be very upset, as I am. Right? You'll see the numbers. It should shock you. It should shock all of us. And then the question becomes, we need to take that feeling and move it towards action, encouraging our elected leaders to provide necessary funding. Keisha, I'd love to hear your thoughts. What would you invite folks to do here related to this issue?
On funding, I think one thing that we've been really successful in doing is making sure at the Defender Association that we're out in the community and educating people about why we're important and why they should, reach out to city council members, to the mayor, to their state senators and representatives, to the governor to raise the issue of why we need public defense funding. And when we're out in the community, we get a lot of questions regarding what is our role. Unfortunately, I don't think there's been a show yet on television that portrays us in a good light. And so, I would love to be able to have, a primetime show a public defender as a hero that does incredibly important work and is effective and zealous, an important part of our system, but we haven't gotten there yet. So I think because of the education that we need to keep doing, We are not in the public eye as a priority as much as we need to be, but we're getting there and we're making that progress little by little. I think the next step for us, I'm going into this budget cycle asking for $15 million. I'm not expecting to get $15 million, but I'm going to fight like hell to get that $15 million, which is, it's going to allow us to do, incredible work for our clients, expand our work in certain areas like social services, and also pay our attorneys more. Right now, public defenders in Philadelphia start at $64,000. The district attorney starts at $70,000, and people at the law department start at $72,000. And so there's a lot of work to be done. As the chief defender in Philadelphia, certainly for Philadelphia, and we have a representative on the Indigent Defense Advisory Commission. We have allies in Senator Hughes and champions in Harrisburg and in the governor. And I think, to get much, much more robust about pushing for needed funding.
Thanks. Ben?
Sure. I think my concluding thought, building on what Commissioner Ellis said earlier about the need to bring in storytelling into policy change, is I think that storytelling is critical in the stories of real people. And I also agree that sometimes, the work of researchers, statistically intricate, empirically complex stuff is not particularly useful. But I want to make a pitch for the role of just basic math in policy change. And just a quick anecdote from a previous job I had where I worked for someone in Commissioner Ellis's position in Los Angeles County. And there had been this big environmental disaster in Los Angeles County, and it was the state's responsibility. And the governor announced with big fanfare, the governor said, "We are going to give $7 million to this cleanup effort." And we kind of went back and did some quick math with this and realized, whoa. So what we did was we went up to Sacramento, bus full of community organizers, but also some people who could do basic math. And we printed up these posters that said, this number of homes are impacted times this number of dollars to clean up each home. And the total of this on this simple placard was the total cost of this is $400 million. So not $7 million, but $400 million. And 2 weeks later, the governor revised his estimate, his allocation of money from $7 million to $176 million. And I say that just to say that there is research that is published in academic articles, but sometimes you can really tell a story with basic math. And I think one area you can do that in indigent defense funding, everybody gasped when Director Hudson mentioned the number of cases that one lone defender out in that area had. And those are really compelling numbers, and I hope they are useful to policy change. And if policymakers don't change, I think litigation is the tool to use to sort of force them to do what they're required to do.
Well, please join me in thanking our wonderful panelists. So we're going to take a short break, and I think 10:40 we'll reconvene for the keynote from Dan and Lester.
Thank you. Thank you.